Welcome and hello everyone. My name is Attorney Feener and I am an attorney located in Boston, Massachusetts with a satellite office in Stoneham, Mass. During the course of this informational segment, I'd like to focus on the issue of what to do if you or your business is sued. Before I begin discussing the subject matter of this informational video, I'd like to briefly summarize my background. I have been in business as an attorney for more than 30 years, providing legal services with a concentration in homeowner and property-related insurance claims. Prior to starting this office, I worked for approximately 20 years in the insurance industry in the property claims arena. With respect to the issue as to what to do in the event that you are sued, I offer the following for informational purposes and not as legal advice. First and foremost, although it may seem obvious, do not ignore the lawsuit. In Massachusetts, you have certain time limits in which you need to respond in writing to the complaint. Generally, the time limit is calculated based on the date that you were served with the complaint by either a sheriff or process server. In certain cases, for service can be made by certified or registered mail. Your response needs to be in writing, sent to both the court and the party or the attorney who is bringing the lawsuit against you. Generally, although there may be certain exceptions, an answer or what is known as a response of pleading to the complaint needs to be filed with the court 20 days after you or the business was served with a complaint. Generally, if your organization is a corporation, LLC, or LLP, or a similar legal entity, you as the business owner cannot represent yourself in court, and you will need to be represented by an attorney. There is an exception to this. Generally, if you have been sued in small claims court, a written answer is not required, and an attorney is generally not required unless the party opposing your self-representation objects. Next, you should not fire off an angry telephone call, email, or letter to the party that sued you. If the party suing you has gone through the time and expense to file a formal lawsuit with the court, they're not going to respond to an angry letter or an outraged phone call or email. What you need to do is begin organizing your documents and records to support your position in defense of any claim that has been brought against you. You should then contact an attorney, and in that initial meeting with your attorney, you should be prepared to bring with you key documents concerning the matter, along with possibly a timeline of the various events that took place, in order to assist the attorney in evaluating the case and formulating a tactical response. A tactical response could include contacting the opposing attorney, the opposing party, or organization that brought the lawsuit. In the alternative, the response may be to draft either an answer to the complaint with a possible counterclaim or a motion to dismiss. Should you have been served with papers for a lawsuit, such as a summons and complaint, please feel free to contact the law office of Attorney Feener. For additional arrangements or information, you may wish to visit our website at www.attorneyfeener.com or www.homeownerclaims.com. In conclusion, I'd like to thank you for listening to this informational segment and remind you that this informational segment can be considered to be advertising under the ethical rules. Any selection of an attorney should be a careful and thoughtful decision. Again, thank you for watching this video, and I invite you to watch my other videos concerning homeowner and property insurance claims, and have a good day.